Welcome to Off the Clock, the webcast of employment attorneys at Miller Johnson, where we discuss what is happening in the HR world and provide practical insight and advice. We are your co-hosts, Rebecca Strauss and Sarah Willey, two employment lawyers who spend their days guiding employers through all of the challenges that workplaces offer. Well, Rebecca, I don't think there's much of a question about what we should talk about today. I think in the last 24 hours or so, Miller Johnson published 3 different client alerts on the emerging, changing framework for the federal vaccine mandates. What's been stayed, what's been enjoined, what courts are saying, et cetera. So I think we should provide everybody first just a framework about what these legal challenges are to the mandates, kind of where things stand and what's next. And most importantly, the big question I'm getting from clients is, what should I be doing now?
Right.
Are these things going to stay? Are these things going to happen or not? And should I be turning my workplace upside down in order to comply, or should I just hold off?
Yeah, that is definitely the question of the day, of the week, of the month. And adding to the confusion out there, I think, is that there are actually 3 different vaccine mandates or vaccine or test mandates from the federal government.
Right.
And when news breaks about one, it can be confusing.
It gets confusing,
as to which one and which states does it apply to. Is it national? Is it not? Just yesterday, right, we had 2 breaking cases about the CMS rule and the federal contractor rule, and everyone's heads are spinning. So I think that's a great idea. Let's just make sure we're literally all on the same page.
Right. 3 mandates and about 100 lawsuits, right?
It's like they care about Miller Johnson. And are trying
they want us to be engaging with each other after 9 p.m., right?
Yeah,
to be writing client updates for
So should we send the federal government a fruit basket? And
I think we should.
What is the address?
both them and all of the lawsuits that are getting filed, right? Everyone filing the lawsuits and all the judges issuing slightly different opinions, doing slightly different things.
Right.
So
let's take a little trip to Geekville for a minute.
Okay, I like it. Yes.
And getting back to our
Wait, does this mean I'm a geek? Is that what you're trying to tell me?
No, it's just a one-day trip. I live there.
I think I'm going to find that it's not really a trip for me either.
That's where okay. I live. You're going to take a one-day trip there to visit me. And we're going to go all the way back to things that we have not wrestled with deeply, probably since law school, and things we normally don't talk to clients about.
Right.
Because it's really in the weeds, right? About what is the legal process here? What is the process for challenging these things? And where are all of these challenges in that process? Because I think once people understand the framework, it'll start making sense. And when they see a headline break, right, we'll all understand how it fits in, right, to the framework. And the framework applies to all 3 mandates, right? The legal framework, how do you file a case challenging a new federal rule? Who hears it first? What's the appeal? What's the schedule like? That applies generally to any sort of challenge, right?
True. Yeah, absolutely.
So let's, and we are going to get into the weeds as to where each one of these mandates stands. And as you mentioned, the practical. Well, what the heck do I do in light of all of that? But let's just start at the beginning. And I'll kick us off. Is that okay?
Yeah, that sounds great.
Okay. I always wanted to be a law school
Let's put
professor.
on our seatbelts for our trip to Geekville. Yes, I'm ready.
Here we go. In each one of these situations, a federal agency put a burden on employers to tell their employees they had to be vaccinated, or in the OSHA case, vaccinated or test and mask, right? 3 different agencies, right? We've got OSHA, we've got CMS, and we've got, just the executive branch, right, dealing with federal procurement of contracts. But that's how it all started. And so attorneys generals, mostly Republican, attorneys generals from various states filed lawsuits challenging the federal government's authority to to issue those rules. And what's really interesting, Sarah, in all three of these, what was actually pled in the complaints are not the talking points that we're hearing.
Right.
What are the talking points you've heard about the basis of these?
Right. So number one, top of the list, is the constitutional argument. Right.
What do you mean by constitutional argument?
Right. That it would be unconstitutional for the federal government to tell me what to do with my body, right?
Yes.
Or to tell me to inject a vaccine into my own body.
Violation of my privacy right.
Exactly.
It's that sort of an argument.
Right.
Yeah.
That is not the argument that's being made in any of these lawsuits.
Nope. And as we know, because we're going to talk about, several of them have been successful, that's not the basis of any of the successful arguments. Constitutional arguments are definitely part of them, though. They all share a few things in common. They all share claims that the government went about this procedurally
the wrong way.
Wrong. Like in CMS, for instance, that there was no notice
Right.
and comment period, for instance. And they all talk about each one of these agencies exceeding the authority granted to it by Congress. Okay, so let's get out of geekful for a minute. Go back to high school civics. You remember high school civics?
I do.
I really don't.
Do.
But my kids are in high school.
We called it government.
My kids are in government in high school, so I'm relearning, just like I had to relearn algebra. I'm going to civics with them. And if we remember, there's three branches in separation of powers. The judiciary, of course, the legislature makes the laws, and the executive branch enforces the laws, right?
The judiciary interprets them.
And the judiciary interprets them. And so the legislature in some situations has granted the executive branches, the federal agencies, if you will, the authority to do certain things, but they can't delegate their authority to make the rules, right? They make the rules and the executive branch just enforces. And so with all of these cases, the plaintiffs have said, you have exceeded the authority that Congress gave you.
I see.
Congress said you can do some things to enforce the law we passed, but you can't actually change the law. You can't make new, breaking, hugely impactful law through regulatory action, right? Rulemaking. So that is a constitutional argument, not the kind that everyone's talking about, but that is a constitutional argument, a separation of powers argument, and that runs through all three challenges to all three agency rules, right?
That particular agency, whether it be CMS or whether it be OSHA or whether it be the Office of Budget and Management, all three of them only have certain powers, and the rule or mandate that they issued exceeds the power that they have.
That is the theme. The courts that have agreed with the plaintiffs have all agreed on that point. The arguments are a little different depending on the agency, because each agency has its own authority, right, as drafted by Congress. So it's a bit of a separate analysis, but it's the same theme.
Same idea.
So let's talk about the process. Okay, so a bunch of states filed a bunch of lawsuits. A bunch is a legal term of art, by the way.
Yeah, right, exactly. Many, several, more than several. You're right, I think it's a bunch.
Because it's a bunch. And in some cases, a bunch of states got together and filed some together in different bunches around the country, which has added, I think, to the confusion of what the heck is happening here.
Right.
Some went straight to the Court of Appeals. For instance, the folks challenging the OSHA rule went straight to the Court of Appeals. There is a way to do that under a little-known part of federal procedure. The other challenges to the CMS rule and to the federal contract rule went to the district courts first.
That's a trial court.
A trial court.
That's
so
not the appeals
the judiciary system is set up in three tiers, right? You have the district courts, the trial courts, the courts of appeal, which hear appeals from the district courts, and then we have the United States Supreme Court sitting on top.
Three steps.
So OSHA, the challenge to OSHA started in the middle. The challenges to the other two started at the first.
Sure, and that was based on how those lawsuits were filed by these states, and I think we can assume that that was very strategic on their part.
I'm assuming so.
Exactly, and so where they filed geographically was strategic.
Absolutely.
And whether they filed first at the lowest level, the trial level, or the appeals court level was also very strategic on their part. ultimately, though, we do know that all of these cases are headed to the same place, right?
Yes, and that place
Which is the U.S. Supreme
US
Court.
Supreme Court,
Right.
that's right.
So regardless of where it gets filed in the first place or the strategy that was followed, some lawyers often call it forum shopping, right?
Right.
It will follow the process of appeals up, and these will all ultimately get decided by one court, and that's the U.S. Supreme Court, and then that decision will be the final decision with regard to all three.
And we all have to kind of just hold our breath until they get there. It will take some time. I don't have any inside knowledge on this, but I assume the Supreme Court is going to fast track the briefing and oral argument
Oh, sure.
on
Right.
these. Normally it could be years, right? From the time a case gets filed in
Yes.
the district court until you get a decision from the United States Supreme Court. I don't think it's going to be years. I would say months. And I would count in months instead of years.
Right.
So we will have a final answer here in some number of months, probably less than 12. That's just a guess. All right. What do you think? When will we hear?
Oh, I think that's right. Yes, I think I'm hearing a lot of HR folks say, am I going to have to worry about a final decision coming down over the holidays, right?
Yeah.
Can I go on my planned trip or take my planned time off,
Right.
or am I going to be here on New Year's Eve or New Year's Day collecting vaccination cards, right? And I think the answer to that one is it's okay. Take a deep breath.
Right.
It's unlikely that we're going to be seeing a final decision from the Supreme Court this year, meaning 2021.
Right.
I think it's going to be sometime in 2022. Now, in the meantime, it is possible we're going to have some back and forth as to the status of each of these mandates and whether there's been an injunction or a stay or not. Let's do this. Why don't we go through each of the three more specifically?
Good idea.
And talk about where each of them sit.
Why don't you start with the OSHA rule, because that probably it does impact the highest number of folks out there, right? It has
I think
the
so, too.
broadest
Yep.
coverage. I like to call it the OSHA ETS 100 plus. Sounds like a kitchen gadget.
It does. It
And
does
I love
sound
a
like
good
a
kitchen gadget. So
Okay.
takes
So
the sting out of it a little bit for
yes.
me.
So OSHA, right, which is starting way at the beginning. OSHA is our federal agency, as you mentioned. It's an agency in the executive branch that is tasked with the enforcement of workplace safety standards. Okay.
Okay.
It's OSHA stands for the Occupational Health and Safety Administration. And so Congress has given OSHA certain powers in order to make sure that workplaces in our country are safe for people. Okay?
That makes sense.
It makes all the sense in the world. OSHA issued something called an emergency temporary standard. Now, to be clear, usually when OSHA issues workplace rules and standards, they have to follow a notice period, right? They've got to give employers advance warning of what they're doing. They've got to get comments, give employers and industries an opportunity to comment on what they're doing, et cetera. It's a process that takes a significant amount of time, okay? An ETS, an emergency temporary standard, on the other hand, shortcuts all of that, right? It's a process by which OSHA is allowed to do what they did in this case, which is just publish something in the Federal Register telling employers what they have to do and expect them to comply with it in a very short period of time, okay?
Okay.
Congress has said they are allowed to do this, but only under very limited circumstances. Number one, OSHA has to show that there is a grave danger to employees in the workplace. In the workplace.
In the workplace is key. You're going to come back to that, I
Yes,
think.
right?
That's a key
So they've
phrase.
got to show there is a grave danger to employees in the workplace, and they've got to show that this ETS, this emergency standard, is necessary, right, in order to address that grave danger to employees, okay? So when OSHA published the ETS, they obviously took the position that COVID is a grave danger to people in the workplace, and that this rule, this standard is necessary in order to address that. Okay?
Okay.
Now let's talk just for a minute, a reminder about what the ETS says, because I think it's going to help us sort out what the courts have then said, right? Mm-hmm. So the ETS says that employers have two different deadlines in order to do certain things in their workplaces, right? Employers of 100 or more employees. Mm-hmm. By December 6th, they have to implement a policy. They're supposed to determine who's vaccinated and who's not. And if employees are not vaccinated, they're supposed to make them wear masks. They're supposed to provide certain notices to employees, provide opportunities for employees to get vaccinated, things like that. Mm-hmm. Okay. And then by January 6th, employers are supposed to require employees who aren't vaccinated to be tested at least once a week.
That's when the testing starts.
That's when the testing starts.
January, because as we know, that's
so
a key.
Masking in December, testing in January.
Okay, got it.
Along with then other administrative things that need to be done. Okay. Now you mentioned lawsuits were filed, right?
Yes, lawsuits were filed. I can say that with confidence.
Yes, lots of them, right? So what happened next was that lots of lawsuits were filed. And as you mentioned, one of the first ones was filed immediately with a federal appeals court, right? And that was the Fifth Circuit.
That was the Fifth Circuit, which has a reputation. Folks should know the Fifth Circuit has a reputation of finding that executive agencies exceed the scope of their authority. They are more likely than other courts, perhaps, to get there.
So they might have been forum shopped, is what you're saying.
Not accusing anyone of anything,
yes.
but there could have been some strategy
Okay, got it.
involved in that decision. Yeah.
And what is the Fifth Circuit done?
So what the Fifth Circuit did is they twice, first quickly and then after a little bit more thought, but basically saying the same thing, said that there is a likelihood of success of the complaint. And that's just part of a normal standard that any court has to decide, right? Mm-hmm. When someone brings to them a request for what's called either a temporary restraining order or a preliminary injunction. So we should probably pause there and explain what those words mean, and the word stay, right? Because these phrases are
floating around out there.
Are
sure.
floating around everywhere. So an injunction is to enjoin someone, to tell them either to do something or not to do something, right? This is separate than paying money damages.
It's an order.
Not a criminal,
Sure.
right? No one's going to jail. But an injunction is an order from a court that says either do something or stop doing something. Mm-hmm. And a temporary restraining order, a preliminary injunction, is an injunction that happens at the beginning of the case instead of the end of the case. So normally, you have to go through a case before a judge makes a decision, right? And for any of our listeners that have been through litigation with us, they know that can take a year or sometimes years, right? There's gathering of evidence, there's depositions, there's hiring of experts. It's a process. And then the judge makes a decision, or a jury makes a decision, based on all of that information collected during the lawsuit and presented to court, right? A preliminary injunction happens right out of the box. A lawsuit is filed, a motion is made for a preliminary injunction, and those are requests to the court that are based on the argument that we can't wait a year or more, right? If we wait a year or more to the end of the case to get a decision or injunction, it'll be too late. The parties will already be harmed, right? And it's the kind of harm that you can't undo. In other words, it's not just money changing hands. It's someone that's going to be vaccinated, someone's going to lose their job and then their house, et cetera, et cetera. The slippery slope of horribles that can happen if we don't do something at the beginning of the case.
But to be clear, a preliminary injunction is not a final decision about whether, in this case, whether the mandate should stand or not. This is just the court saying, we think the plaintiffs here, the parties who filed, the states who filed the lawsuit, might win. We think they have a good enough chance of winning that I'm going to issue an injunction telling OSHA that while this litigation is happening, OSHA cannot enforce the OSHA ETS.
Right. It is preliminary injunctions, by their own definition, are temporary in nature.
Okay.
It's just telling everybody to keep in their current positions, no one change, no one do anything, until the court has a chance to hear the whole
To
case.
take the careful review and have it go through that process.
Right.
Okay,
Yeah.
so no court as of yet has made any sort of final decision about whether the OSHA ETS is enforceable or not. All that's happened is that the Fifth Circuit in this case issued that preliminary injunction saying, OSHA, you cannot enforce this while these lawsuits are pending.
That's
correct.
Right. The
Okay.
only decision that's been made is temporary
Okay.
In nature. But you and I have been referring to the Fifth Circuit, Sarah. Why now are we hearing about the Sixth Circuit being
so
involved
this is
in
really fun because
well, for us
it involved it involved a process that, quite frankly, I didn't know existed.
Yeah, it's kind of arcane, right?
Yes.
Yes.
Yes. So what happened is that so many lawsuits were filed in so many different federal courts, right, that the federal rules that apply to federal courts have a procedure by which they have to all be consolidated,
Right.
and assigned to one appeals court, right? Is that correct?
Yes, this is for judicial efficiency because it doesn't make sense for
Oh
lots
my
and lots of
goodness.
courts around the country to all be hearing the exact same case.
We would have 50 client alerts a day,
Yes.
right?
Let's
Our
not go there.
marketing department would lose its mind.
They sure would. And so so the Fifth Circuit, by the way, knew that was happening. That was going to happen right off the bat. But they got their decision out before
right.
the Court of Appeals selected the one that would hear all of them. And how do they, this is kind of fun. It's not really important to the outcome of the case, but it's just kind of fun to talk about. How did anyone decide that it would be the Sixth Circuit of all circuits? It's a lottery.
It's a lottery. And I have so many, by the way, I have so many questions
just
about
a
how the
lottery.
lottery's done.
I think it's a ball that they
Do
pull
they
out of
put
a
all
bowl.
the 13 appeal circuits in a hat and pull one out?
Yes, I actually think that's how
Oh, my
it's done,
goodness.
which is.
I wish they had live streamed it because that would have been fun to watch.
Do you remember on TV years ago, the lottery, like after
Oh,
the
yeah.
evening news with the hopper, like the bingo hopper?
Yeah. Anyway, okay. So they had the lottery.
They had the lottery.
And the Sixth Circuit won, although I'm not sure they would view that as winning. Not sure the clerks and the justices on there, or the judges on the Sixth Circuit view it as a win. But the Sixth Circuit won. It was kind of exciting for those of us here in Michigan because the Sixth Circuit is actually the federal appeals court that hears federal appeals in Michigan
That's
and a
right.
number of other states in the Midwest.
Michigan, Ohio, Tennessee, and Kentucky. Those are the states that the Sixth Circuit.
I know. So they won, and I felt like saying, "Oh my gosh, I've been there." Right? It's like a
Right.
it's like a celebrity.
I worked there.
Yes.
Yes, I'm like, I know the
Rebecca
building.
worked there.
Yeah,
Wow.
what fun. So
Okay.
what's going to happen now? So it went from the Fifth Circuit, now the Sixth Circuit, right? So all the cases around the country where bunches of cases were filed
Yes.
are all consolidated now as to the OSHA litigation in the Sixth Circuit. And we've gotten lots of questions about when are we going to hear
Yes.
something from the Sixth Circuit.
Well, let me ask you this first. Could the Sixth Circuit undo the Fifth Circuit's injunction?
Absolutely.
Okay.
Yes, the Fifth Circuit's decision is not binding.
On the Sixth
on
Circuit.
the Sixth Circuit.
Okay.
The Supreme Court's decisions are binding on the Sixth Circuit, but a sister
Okay.
circuit, as they call them, those decisions are not binding. So the Sixth Circuit will be taking a fresh look at the challenges to the OSHA litigation and deciding whether to maintain the stay that the Fifth Circuit imposed,
And also
or whether
making
to lift it.
an actual decision about whether the OSHA ETS is enforceable, whether OSHA followed the
Right.
correct administrative procedures, and whether it's otherwise constitutional, et cetera, right?
Right. We
Okay.
will get another court. We know how the Fifth Circuit feels now. But another court will get a
Okay.
stab at it, and from there it will go, as you mentioned earlier, will go to the Supreme Court.
Okay. Now, today is December 1st. And by the way, we should be clear about that in this podcast, right?
Yes.
Because everything we're saying today is as of
We should probably say at 10:30.
at 10:30 a.m. on December 1st.
At
right?
11:30, who knows what will be happening.
Right. Today is December 1st. I think many businesses understand that as of this moment, OSHA can't enforce the ETS, right? So they're not required to be complying with it. But that first deadline is coming up just in days. So I'm getting a lot of phone calls and emails from clients saying, is there any chance that this injunction is going to be lifted or that this is going to change before December 6th? Should I be scrambling right now to try to get into compliance? And I think we know the answer to that, right? Because we know the briefing schedule of the Sixth Circuit.
Yeah, so the briefing schedule is the schedule the court assigns in every case as to when brief the legal documents
Right.
where the parties get to explain why they should win, right? These
Yep.
take time to prepare, as we
Yes.
both know. You can't do those overnight, right? And this is obviously a very important issue for the country. So the court always sets a briefing schedule. Plaintiffs, your brief is due this day. Defendant, your brief is due that day. They did it in this case, and there's a back and forth of briefs, but the last one is due December 10th.
Okay.
So we're probably not going to hear it before that.
It is highly unlikely that anything is going to change before December 10th, and in fact, highly unlikely that anything would change on December 10th, because even after the Sixth Circuit gets all of the briefs, then they need to evaluate it and have some time before they would do anything, before they would act, right?
Yes, I think they could act quickly if they want to, right? My guess is there's a lot of research and writing and
That's
prep
being
work
done already. Sure.
behind the scenes.
Okay.
Yes, right
Okay.
now. So it will depend on whether they want to act.
Okay. I
not
see.
whether they want. Whether they want to, whether they're able to, depending on who agrees
Okay.
and who disagrees. There is also right now a debate about whether it will be a panel of 3 judges in the Sixth Circuit, which is typically how an appeal is heard, right?
Okay.
In any of the circuits. It's there's, I believe, 18 judges on the Sixth Circuit, but typically a panel of 3, which are randomly selected, are assigned to each case. The government has filed a motion asking for that to happen. There is a procedure to fast track it so that every judge on the Sixth Circuit will hear the case at the same time. Because normally what happens is you get the panel of 3, they either decide for you or against you, and if against you, you can then ask for the full court
right.
review. It's called an en banc review. So the plaintiffs in this case would like the states, right, challenging the OSHA rule, would like to fast track this and take it to the whole
Right
panel.
away, rather than skip the
whole court.
first step. Got it.
Yes, and there's a little strategy in that, right? Because most of the judges, 11 of the judges on the Sixth Circuit, were appointed by Republican elected
Right.
presidents, and the 6 or 7 others were Democrats, so they think they'll have a better chance of winning, right?
Although judges are not, just to be clear, judges are not supposed to be evaluating the law according to their political
That
bent, right? They're supposed to apply that. And I think many judges would, quite frankly, take offense to the idea that because they vote one way or another, that's going to impact their legal analysis. in the
having
case.
clerked for 2 judges, I can tell you that it is offensive, and judges bristle at that. But that does not stop litigants, right, from assuming certain things
That could be the
based
case.
on
Sure.
the political makeup
Okay.
of the panel. Yeah.
Okay. To sum it up, the OSHA ETS is currently sitting with the Sixth Circuit. It's unlikely we're going to see a change to the current injunction before that first compliance date.
Right.
Okay. More likely to be that we would hear something from the Sixth Circuit maybe mid-December or so, something like that.
Yep.
And then once that decision is issued, one way or another, it's going to get appealed up to the next level, correct?
Correct.
So what are you telling clients who are asking you, Rebecca, or are concerned that their obligations under this OSHA ETS are going to change overnight, right? Today, there's an injunction, and if it gets lifted, does that mean on December 15th, it's lifted? Does that mean I'm going to be expected to be 100% in compliance immediately on December 15th?
And that is the question of the hour.
That's the million-dollar question, right?
Yes. So my take on that is I can't imagine a world in which OSHA would cite an employer for
Right.
non-compliance because of all of the litigation wranglings and the stay and all of that. I just cannot, I do not believe that will happen, and I believe it is likely, if the stay is lifted at some point by some court, that new dates either will be in the new order
think that's
or the
right.
court, as part of its order, will order OSHA, right, to tell
extend the dates.
employers
Right.
what the new compliance dates are that give employers enough time to bring themselves
enough
into
time,
compliance.
right? So at a minimum, I think as practical advice to those employers who are concerned about that, what I would
Yeah.
say is, if the stay is lifted, it's highly, highly unlikely. I agree with you. I can't imagine a world in which OSHA or the state safety agency is going to be knocking on your door the next morning saying, show me all of your records, and is everyone wearing masks, et cetera. But you would want to be prepared to demonstrate then that you are working toward compliance.
Right, and that's what most employers are doing,
Yeah.
by the way, I think, right? Has that been your experience
Yes.
too?
Yep.
Not pulling the trigger on starting the new policy, but they're at least working on getting a policy in place, right?
Yep.
Which is probably good housekeeping,
Absolutely.
frankly. They're working on sourcing tests, figuring out if they're going to do those on site, if they're going to send their employees off site, how that's going to work. Are they going to have on-site vaccination clinics, et cetera, because that's a tremendous amount of work.
Yep.
To figure out those logistics.
I agree with you on that. I see them really doing three things: the policy, the figuring out the accommodation process, of course, right? Getting my forms in order, thinking that through, and then the testing piece, starting to talk to local labs and think through how are we going to do this.
The testing piece, by the way, I know we've said this in private, so I sound like a broken record, but I'm not sure if I've said it on a podcast, so I want everyone to hear me say it. The testing piece of this is really the most time intensive.
Yeah, it's very complicated.
And people don't talk about it a lot. This is
Right.
all talked about as a vaccine mandate. This is not a vaccine mandate. Employees have two equally good choices, according to OSHA. They can say everyone has to get vaccinated, or they can say you don't have to get vaccinated, but if you don't, you have to submit to weekly testing.
And wear a mask.
And wear a mask in the workplace. And in my very unofficial surveys of clients, everyone's going for option 2.
Sure.
Right? So if that is true, there's going to be a tremendous strain on the resources for tests. And clients are trying to get their heads around how are we actually
Right.
going to make that work, because let's not get too far in the weeds of the OSHA rule, but as we know, there's rules about how you can test and what kind of test and who has to proctor it.
What about that CMS mandate?
CMS, and as I like to say about the CMS mandate, if you don't know what CMS stands for, it doesn't apply to you.
I was just going to say, should we tell them what CMS stands for?
Center for Medicare Services.
Yes, that's exactly right.
And so for folks that are that have agreed to the standards of participation for Medicare,
Right.
A lot of what you do is governed by CMS, right?
Correct.
Yes, now the vaccine mandate is an added layer onto that, but this is not something you can just stumble into or frankly need to call Sarah and I to figure out. Someone in your organization knows.
Yeah, otherwise said, and
whether
we-
you're
and we've said
participating
this-
with Medicare.
Yes, we've said this before. Just because you accept Medicare and Medicaid funds doesn't mean that you are a Medicare and Medicaid certified
Right.
practice.
You have to agree
So-
to conditions of participation.
Yep, exactly.
Which are
So-
lengthy. There are lawyers that just help organizations comply with those. And if an HR person listening to us doesn't know, your CFO will, your
Right.
CEO will. It is a major business decision, whether you are subject to CMS rules. So it applies to lots of healthcare type of organizations in general. Not all, though. A lot of private physician practices, for instance, are not covered by CMS, but hospices, hospitals, nursing homes, others. And again, folks listening should know whether they are covered or not. So the CMS rule that came out the same time as the federal contractor rule and OSHA rule does not give employers those two choices. They have one choice. They have to have a policy that requires all employees to be vaccinated subject to exemption requests,
Yep.
right, for disability or sincerely held religious beliefs. And there's some more detail that the CMS rule gives too, right? What kind of documentation is required for an exemption, those sorts of things.
So where does that stand?
So again, it's December 1st at 10:40 now. 2 days ago, a court issued a stay, an injunction, right, against the government enforcing that rule. But here's what's so interesting, Sarah. That court in Missouri said that stay only applies to the 10 states that were actually the plaintiffs in that particular lawsuit.
Right.
So let's pause for a moment because this is causing confusion. The OSHA stay by the Fifth Circuit was explicitly nationwide.
Yep.
The court said that.
No matter where your business is, that injunction prohibited OSHA from enforcing that ETS against you.
Yes, and as the law about injunctions in general currently stand, courts have a choice. And there's debate amongst the courts about when they issue an injunction, should it apply just to the parties in the case, or
Right.
can they go
Nationwide. Got it.
nationwide? So every time we get a case that comes out on one of these mandates, the first question we ask and the first question clients should be asking themselves is, hold on,
Does this apply to
does
me?
this apply to just the
Right.
plaintiffs in that case, the parties in
Right.
that case? If so, is Michigan or whatever state I'm in, am I in
Right.
one of them, or is this nationwide? So the first court to decide the CMS mandate was in Missouri, and it applied it only to the 10 states
Which
who are
was
parties.
interesting for one day.
Which was interesting for one day because yesterday evening, during my dinner, I might add, a court in Louisiana ruled, and it granted the plaintiff's request for a preliminary injunction to stay enforcement, right? So as we were talking about before, just like with OSHA, it said federal government, you cannot enforce the CMS mandate.
Right.
And that court said this is
Awful.
national in scope. Okay, national in scope.
So as we sit today, there is an injunction prohibiting CMS, right?
Yep.
From enforcing that mandate in all 50 states, just like the OSHA ETS.
Correct.
Okay.
And everything, frankly, we discussed with the OSHA ETS and what do you do now, and there are these dates, do they matter anymore? Frankly, it's much the same conversation.
Yep. Right.
With CMS. So the current CMS deadline, which is coming up right next week, the date by which employees have to have their first shot, right?
Right.
December 6th.
And employers are supposed to have a policy and things like
There's
that.
a stay. It's very unlikely that we're going to hear anything before December 6th. And even if we hear anything shortly after December 6th, there'll almost certainly be extra time granted, right? Now, this case was decided by a district court. So remember,
That's
we
the
went through
first level,
the first level.
right.
It is
bottom of the
guaranteed to be
cake.
appealed. The bottom of the cake. Oh gosh, don't get me started thinking about cakes this early in the morning. So the bottom cake tier, it will certainly be appealed to the middle and
Right.
then up to the Supreme Court too. So this challenge will probably take a little bit longer than the OSHA to get going because they started lower, right? So now we have
That makes sense.
3 levels instead of 2. There may also be a multi-district litigation lottery
We could
process
have another
again.
lottery.
I haven't seen an update on that, but it would
Okay.
not surprise me, right? Because there are a number of cases around the country pending challenging the CMS rule. So now it's
Okay.
national in scope. So all the folks that were complying with the CMS mandate, but not the OSHA
Right.
ETS 100 plus, you're in the same boat as
Right.
the OSHA folks.
Right.
Okay.
One thing I do just want to quickly point out for our listener, again, to kind of reiterate, the parties who have filed these lawsuits have been intentionally selective about where they're filing them. Okay.
I think there's some strategy.
And I think it's important to understand that because most of the decisions so far have gone their way.
But not all.
Not all, but most of them have. And so keep in mind that's not particularly surprising because they're forum shopping. They're selecting the courts that they think are most likely to find in their favor. We may begin to see different opinions as the appeals courts hear them.
Yes, but what's so interesting about the strategy of it is that you only need one court to agree with you and issue the national injunction, right?
Yeah,
You could
right.
you could
That's
lose
right.
that argument in 10 different cases in 10 different courts.
Yeah.
But as long as you get one that then issues a national injunction, you've got the relief that you wanted. And in fact,
Temporarily,
there was a
yes.
challenge to the CMS mandate in Florida that lost. And that judge did not issue a temporary injunction, but then 2 other district courts did.
Did, yes.
Right? And this is a perfect setup for a Supreme Court decision, by
Yeah.
the way, when you have conflicting decisions amongst
Okay.
multiple courts. So, are we ready?
Last, let's talk
not
about
least.
last, but definitely not least. This one is really interesting to me, where it sits as of today.
Yeah.
The mandate for the federal contractors and subcontractors. Okay, where does that stand?
So, as of yesterday, November 30th, a court out of Kentucky
Okay.
agreed with plaintiffs that that rule was unconstitutional and exceeded the mandate or the authority by Congress, et cetera, issued a stay of enforcement, but only in the states that were parties to the case. And there were 3 in that case, Kentucky,
Right.
Tennessee, and Ohio.
And Ohio.
Now, but remember what happened with CMS, right? First it was just the 10 states, and then another court said, I'm going to do it, but nationwide. There are other cases still pending challenging the federal contractor mandate that have not been decided yet. There's a case pending in Florida. Oral arguments are scheduled for December 7th. There is a case pending in Georgia. Oral arguments scheduled for December 3rd. So we may see with the federal contractor rule the same thing that happened with the CMS rule, where one court limited its injunction, another court granted a nationwide injunction, or these courts may say no injunction at all, too. So we're going to have to wait and see.
We're going to have to wait and see.
What
And
happens
if
with that.
you're listening to this after December 3rd or December 10th, take a look, right, and see what happened in those cases.
When you hear news breaking about the federal contractor mandate and a challenge to it, your very first question should be, is this nationwide in scope, right? Or does it only impact contractors in certain states?
So current status for the federal contractor mandate is that the federal government cannot enforce that mandate in only those 3 states.
Right.
You know, to me, Rebecca, that's very confusing, particularly for subcontractors, right? Because bear in mind, so the way the federal contractor mandate works is that the federal government includes that vaccine requirement in its contracts with the business with which it directly contracts. That's called the prime contractor, right?
This rule is very different than the other 2 in that way.
Yes, exactly.
Right? Yeah,
So, for
very different.
example, the federal government might contract with Ford, right, to purchase cars. And the federal government then is contract directly with Ford, would include the vaccine mandate, but then also require Ford to pass that mandate down to its subcontractors. Right? And then it keeps getting passed down. Okay? So when we think about the level of confusion over whether as a subcontractor the mandate still applies to you in the context of the 3 states in which it's been enjoined, it almost makes your head want to explode, quite frankly. Correct.
Well, this has been confusing, frankly, since the very beginning of the federal contractor mandate, because the federal contractor mandate, again, is very different than the other 2.
Right.
It applies to contracts, and it requires certain clauses, certain clause, to be included
In contracts.
in
By
contracts. It's
certain
not
dates.
automatically effective as of a certain date, though, if it's not in your
Contract.
So for subs that have to comply with the vaccine mandate, because the primary or whoever is upstream from
Ford.
them,
Let's say Ford.
yeah, so
right.
whoever is upstream from them said, okay, federal government, right, we're renegotiating our contract with you. Federal government, you are saying we now have to include this clause, right? We are including it. And then Ford turns to its subs and says, okay, subs, we had to agree to this clause, and this clause requires us to make sure we put in your contract, right, that you have to have a mandatory vaccine policy. Now it's a contractual issue between the sub and Ford. So for subs that don't have that in a contract with their upstream contractor, they probably don't have to comply yet anyway, right? Because it has to do with when the new contract or when contracts are renegotiated to include
So to be
clause.
clear for our listeners who are subcontractors, right?
Yeah, there's a lot more subs than primaries, obviously.
This court's order didn't change their contract with Ford,
No.
with the primary.
And
So they need to connect. They need to understand what their obligations are with their customer, basically,
If
right?
they're-
If you're a supplier to a prime, you've got to figure out what the status of that is. If you've signed a contract with Ford that says, I will do these things by certain dates, that's still a contract that could be enforceable.
Right. What our recommendation is to, especially if the prime or the organization upstream from you is in one of these 3 states, because remember it's only 3 states now, where the government will not enforce that mandate, to reach out to the contracting officer at the organization
And
that's
find out
upstream
what
from
they
you
want to
and
do.
ask the question.
Yeah, because from a practical standpoint, it's unlikely that, for example, Ford is going to be changing all of its contracts based on what injunctions have been issued by what federal court in this, in all of these cases, right? I don't think that's practical. So we are going to have subcontractors that are under a contractual obligation to still move forward with a vaccine mandate, even if they are maybe located in Ohio, or even if their prime is located in Ohio.
Yes, the federal contract rule by far is the most complicated
That is,
of the 3
yes.
mandates.
Yes, that's an issue. That would be a concern for me that would apply even if and when a federal court issues an injunction in all 50 states, like has happened with the OSHA ETS and the CMS orders.
Right. It has occurred to me that subs may want to hold off renegotiating contracts, right, with their upstream organizations until this gets sorted out in the next week or 2, right? I just gave you the dates of the other cases when we're likely to find decisions. It also, probably the primaries or the upstream folks probably also want to put off renegotiating contracts, right, while all of this is in flux. But the bottom line is, for a lot of our subs, this is a customer relationship issue and contracting issue, right, with the customer, and they need to reach out and ask them for guidance.
That's helpful.
Yeah.
All right, boy, a lot to unpack today.
I think that's enough for now.
I think it's enough for now. Yes, thank you to our listeners for going to, what'd you call it, Nerdville? Geekville. Geekville with us.
Where I live. Thank you for joining me for today as the situation evolves, which it certainly will. We'll make sure to keep folks up to date.
Yes, thank you.